We've talked about liens, lawsuits, all that. But what about the contract? Bill, let's be honest. Most of us think of contracts as something the lawyer makes us use. The real deal is what we talk through with the customer, right? How much does that really affect getting paid?
That's how most contractors treat it, and that's where the problems start. A good contract affects getting paid more than anything else. Your contract isn't a backup plan, it's the foundation. It doesn't just protect you, it sets the tone, the expectations, and the what happens if plan. The contract sets the tone, defines the rules, and creates the legal foundation for collecting if something goes wrong. But here's the thing most contractors get backwards. The contract isn't there to protect you after the job goes bad. It's there to make sure everyone understands the rules before you start.
I always figured the contract was your department. Lawyers write it to protect me. I used to think the contract was just legal mumbo jumbo that made customers nervous.
That's a common view, but I see it differently. A contract isn't just legal armor, it's the foundation the entire job is built on. Contractors naturally focus on the scope of work and construction process. Those are second nature, but too many see the contract, and especially change orders, as speed bumps that slow them down. In reality, the contract is what supports everything else: the scope, the expectations, the responsibilities, the what ifs. When you see the contract as a business tool instead of legal red tape, you build with more clarity, more confidence, and less confusion later.
So, what's different between residential and commercial contracts?
Residential construction is tightly regulated in Minnesota. If you're a licensed residential contractor, state law requires you to include the Section 514.011 pre-lien notice, a 3-day right to cancel, your license number, the 327A statutory warranty disclosure, a copy of your performance guidelines, and other consumer disclosures depending on the job. Miss one, and your contract might not be enforceable. You could lose your lien rights or worse. Commercial work doesn't come with those requirements, but that doesn't make it easier, it makes it riskier. With fewer rules, it's on you to spell things out clearly. The only thing worse than a bad contract is no contract at all.
What are the mistakes you see the most?
No payment schedule, no process for handling changes, no interest or collection costs on late payments, no lien notice, conflicting terms between the bid and the contract, and language that was pulled from old jobs or downloaded from who knows where. Even smart, capable contractors sometimes build the entire job on a document they couldn't explain if they had to. That works until it doesn't.
Speaking of paperwork, what about change orders? I usually confirm by email or text. That should hold up, right?
It might, but only if the customer is being reasonable. If they decide not to pay, that casual confirmation turns into a weak spot. A written signed change order avoids the fight. It's clear. It shows the customer agreed to the work and the price before you did. An email thread can help, but it's no substitute for a real signature when there's money on the line.
Yeah, but getting signatures slows things down.
Only at first. Once it's part of your process, it's just another step, like ordering materials or scheduling subs. It's not red tape, it's clarity. And clarity gets you paid.
My customers don't like signing stuff they don't understand. Sometimes I feel like the contract just makes them nervous.
That's because too many contracts are full of legal jargon. Even the contractor doesn't fully understand it. So when the customer has questions, the contractor shrugs or says, "That's just what my lawyer put in." But when you understand your contract, when it's written in plain language, with terms you can explain confidently, it becomes part of the conversation, not an obstacle. Customers are less likely to push back or send it off to their lawyer when you can walk them through it line by line. That's how you shift from being the contractor with paperwork to the professional they trust to deliver.
What if the customer wants to change something in the contract?
If it's not something required by law, you can change it as long as you both agree. If it's a big change or one that affects risk, I'd recommend having us take a look. But if it's small and you're comfortable with it, cross out the original language, write in the new one, and have both sides initial it. The key is being confident enough in your contract to make adjustments the right way, not just saying we'll figure it out later.
But doesn't a long legal contract scare off customers?
Not if it's clear and consistent. A well-written contract shows you're organized, experienced, and serious. It sets expectations and makes you harder to push around later. The more comfortable you are with your contract, the easier it is to explain it to your customer, and the less likely you are to run into disputes or delays when it matters most.
All right, so how do I fix mine?
We start by reviewing what you've got. Then we build a clean, customized contract that reflects how you actually do business, residential, commercial, or both. It doesn't need to be long, it just needs to be clear, complete, and usable. Once it's in place, you use it every time. You train your staff, you get comfortable with it, and you stop being the guy with the one pager and the excuses.
So the contract isn't about covering my backside. It's about getting everyone on the same page from the start.
Exactly. It's not just legal armor, it's your project foundation. You don't start building without a footing. Don't start a job without a contract that actually works.